Good morning, Council. The next case we will hear is the Technical Professional and Office Workers Association of Michigan versus Daniel Renner. This is also a 15-minute mini oral argument on the application. That means, Mr. Guido, you may try to reserve some time, but I assume you see how that goes. And good luck to you, and good morning.
Good morning. May it please the Court, Frank Guido, General Counsel to the Police Officers Association of Michigan, appearing on behalf of the Appellant Technical Professional and Office Workers Association of Michigan, and time permitting, I would like to reserve 2 minutes for the vote. The Public Employment Relations Act, which we refer to as PARA, does not prohibit our pay for services procedure. The Court of Appeals and Merck have attempted, under the concept of equality of representation, to fit us a square peg into a round hole. Equality of representation is not the issue in this case. It is not relevant to whether our internal procedure is valid or not. To an extent, this is a case of first impression for this Court. There is no prior case law in Michigan addressing this issue. If we allow the Court of Appeals and Merck decisions to stand, we will in essence have judicial and administrative legislation, because PARA will be rewritten by how they have interpreted that law. It would be a denial of what PARA allows and a denial of what PARA does not in fact prohibit. So as this case of first impression, we have to take a fresh look at PARA and what it requires. PARA, as I said, does not prohibit the pay for services procedure because there's no express or implied language within that statute. If there is no language, we cannot be held guilty of violating the law to have been claimed to have committed an unfair labor practice. And that's a label we don't like having associated with our association if there's nothing in the law that says we can't do what it is we did. PARA, in fact, does allow our pay for services procedure. Section 10(3)(c) of the law makes it clear that the only thing you cannot do is charge a payment if it is made a condition of continued employment. Our procedure is not made a condition of continued employment. There was a case that neither the Court of Appeals nor Merck cited, and it was a Merck decision, a 2018 decision, MEA versus Robinson, where Merck actually did talk about Section 10(3)(c) in that case. And interestingly, though it was not germane factually necessarily to our scenario, but 10(3)(c) was involved. And Merck in that case said, well, the memorandum agreement which required payment of dues or service fees was not in that case imposed as a condition of continued employment. Therefore, there is no violation of Section 10(3)(c). And that's a similar scenario to our case. In addition to 10(3)(c), PARA Section 10(2)(a) allows a union to create internal union rules, like our pay for services procedure. And that makes them exempt from Section 9 scrutiny of individual rights under PARA. Now, we submit that our policy does not contravene any embedded, plain, or overriding principle of PARA. It addresses legitimate union concerns, fair sharing, costs, which really is the cost of running the business, and the stability of the union. There's no prohibition written into those procedures prohibiting somebody from leaving the union. No acts of force or intimidation or threat were imposed in the case. So when we look at our rules, what are they addressing? They're addressing acquisition and retention of membership issues. Bargaining unit membership is a broad term. It includes not only individuals who are dues-paying members, it also includes individuals who opt out and don't pay dues. They're all part of the bargaining unit membership. And our policy, our procedure, addresses all aspects. It covers the membership in the bargaining unit, joining and paying dues, opting out, and still being in the bargaining unit, collective representation, which non-paying dues individuals get without having any cost charged to them, direct representation, which we assert they should have a charge cost, fair share responsibility, delivery of services, ability to rejoin the union. All of those things are encompassed in our internal union rules.
Do you agree that it's illegal for the union to charge workers who are non-union for the cost of negotiating CBA?
For the cost of negotiating a CBA, I would say that In our case, we have avoided the issue completely because we distinguish between collective and direct representation.
Well, all right, so you didn't answer the question.
Well, could we charge them? I think we could charge them. But
So
do
you
we
do
charge
not, you
them?
do
No,
not
we
believe
do not.
it's illegal for,
Well, the reason we don't charge them is because it's an issue that affects everybody. Negotiation is the entirety of the collective bargaining agreement in the sense of what wages, hours, terms, and conditions of employment someone is going to receive. And so in the context of where it is collective, for example, even in grievances and arbitration matters or unfair labor practice charges, if those issues affect everybody in the bargaining unit, we are not charging anyone, dues-paying members or non-members, for the costs. The dues costs that we do charge members are principally going, of course, to running the business. They're going to the absolutely astronomical costs that we incur for arbitrating cases. It's an expensive business. It's an alternative dispute resolution mechanism that is not guaranteed by para to anybody, and it's expensive. And so we have to have a way to pay for that process. Members pay dues, non-members we hope.
I think what you said is that it is not illegal.
It
And
would
you
not.
could, but you choose not to.
Correct.
So why do you distinguish between direct services and collective services in your brief?
How do we?
Why do you? Why do you do that?
Because
If you could
we-
charge
we
for
want to
anything,
make
what difference
We
does
want
it
to
make?
make it clear, Your Honor, that for collective representation matters, we choose not to do that. So that these individuals are getting something more than what we think they should get for free, but we are willing to do that. That's a gratuitous act on our part. We don't distinguish it because it has anything more meaningful other than to say, look, we do provide this form of representation to everybody because collectively everybody is affected by it. If I had a class action grievance or class-related unfair labor practice charge that affects dues-paying members and non-dues-paying members, I'm not going to distinguish the cost between the two of them. Some things simply become a practical matter that we can and cannot do in terms of differentiating the costs. But when I have a direct representation case, and it's just that individual's matter, whether it be it a grievance or a contract breach, I can now determine what are the costs associated with that. and
How does the
appropriately
duty of
do
fair
that.
representation play into that? I know we've got this right to work statute, but we also have this very long time duty of fair representation for bargaining unit members. How does that play into it?
Well, the duty of fair representation, of course, is a standard that says that if the union acts in an arbitrary, discriminatory, bad faith manner, then they violated the law. And nothing about the policy in and of itself, looking at it, is arbitrary or in bad faith or discriminatory. So there really is no duty of fair rep issue in this case. It simply is a non-existent factor, and for Merck to have gone down that path, even label it, they didn't consider any of the factors that are associated with that standard to even determine whether the union, in fact, committed some kind of a duty of fair representation violation. So we put that on the side because it's kind of a bizarre claim for them to make against us. This case is revolved around whether this procedure that we put into place somehow contravenes para. But it doesn't contravene para because para doesn't prohibit it. Para doesn't prohibit it any more than dues. Let me pose a question.
Before you move on to that, just let me
Yes.
ask, does the union have any philosophical or ideological disagreement with the substance of this grievance?
No. With Mr. Renner's grievance in this particular case? No. I mean, the employer determined that it was without merit, but it was, I think, a reprimand case. It was not a discharge case of any nature. No, I don't think there was a philosophical opposition at all to the grievance.
Okay.
What do we do about, I think we know there's the Cone case in Nevada. This is novel for us, obviously, so we
Yeah.
sort of look to see if other states have dealt with this issue. That case obviously rested strongly upon the fact that there was an alternative process for the employee. We already know Section 11, everybody agrees, is this permissive section as far as employees' ability to work directly with management. I'm wondering, it appears that Michigan looks very different than Nevada, so I'm wondering how you address that.
I don't believe the Cone case is as limited to that jurisdiction saying, well, the only reason why we're holding what they were holding is because there are some other mechanisms also in place. That court looked at the 1976 NLRB machinist case, which is a poorly reasoned case, an illogical case from the get-go. It was a 2-to-1 kind of a 2-to-1 decision. There was some concurring and dissenting action by one of the members of the NLRB. But this is a case that was predicated on saying that you have to pay and gave no regard whatsoever to the fact that dues members are paying dues for this very same service. They are paying. This is not a scenario where members are doing nothing and we're charging money to the non-member. The member is paying dues. Let me pose an example. Mary's sitting here and John's sitting there. They work right across from each other. And Mary's been a member for 5, 10, 15, 20 years of the union, paid maybe $4,000 to $16,000 in dues over that time. And John's in trouble. John's not in that union. John says to Mary, hey, I'm going to arbitration. And guess what? I don't have to pay. You got to pay for me. And that's just not right. And it's precisely that circumstance that means this case is so important. Because what is happening is an allowance to the non-union member to receive everything that the member gets without having to pay a fair share. And when we look at PARA and we say to ourselves, wait a minute, PARA doesn't say you can't do this. And there's provisions in here that support the fact that you can. You didn't make it a condition of continued employment, you simply put it in there. That circumstance means that we should be able to charge these individuals to have a fair share in service.
So, okay, let's assume I agree with you, that
I will
the fairness piece, is compelling. How do we avoid Janice and bumping up against Janice?
Well, Janice supports us, I think, very, very directly.
Right, there was some language, some dicta, I understand.
Yes, and let me point that out, because whether you call it dicta or not, those are some pretty strong words. Whatever unwanted burden a union faces can be eliminated. Individuals could be required to pay for that service or could be denied union representation altogether. Well, I back up from that and I say, we can pretend like the Court of Appeals in Merck those words were not significant, but they are significant. If equality of representation is not impacted by financial considerations, all the Supreme Court would have to say is, those individuals are part of the bargaining unit. You got to represent them for free. But they didn't say those words. They made a pretty significant pronouncement, call it dicta or not. But we think that has some significance and guidance. Look, the court in Janice overruled a 40-year precedent of the Abood case and simply said on this logic, I won't say simply said, but said on this logic that it was poorly reasoned. I'm not coming to this court on behalf of my client to say you got to overturn any of the law. I'm simply asking you to recognize that the law we already have allows us to do this. Now you might say, well, why hasn't this happened before? For a pretty simple reason. We had agency shop in this state for years and years and years. And my principal client, the Police Officers Association of Michigan, which is the parent of the TPOAM, was under the right to work law exempted. So it wasn't even until Janice in 2018 that the agency shop was eliminated for them. We didn't even have this issue come up. It never came up. But that's not to say that then historically financial considerations were not part of the process of PARA and the relationship of individuals to a union. It absolutely was part of the process. Financial considerations have always been an issue. And for us to sit back now and say, look, if you want services, we are here to give them to you. But if you're going to demand services from us, you've got to pay a fair share. You can't expect the dues-paying members to shoulder the burden for something that you want. And guess what? While you do that, you still get to stay opted out of the union. You still don't have to pay union dues. You still get the benefit of collective representation. But for that one-off case that you may have an issue, pay for what you're asking to be received as a service. That's not fundamentally wrong. That's in keeping with the whole concept of what we are in a labor relations state like Michigan. And I know I digress when I talk about the Compulsory Arbitration Act in Michigan, because that deals with police and fire, but the preamble to that statute talks about maintaining labor peace and doing the things that keep that kind of a status. You rule against this case here. You support, you and John, I'm talking, but in the concept of accepting the Court of Appeals in Merck is the slow bleed death organized labor. Because Mary, at some point, is going to say, I'm tired of this. I gotta pay for this guy, I gotta pay for that guy. Mary didn't want to do it that much longer, and nor will anyone else. So unless we have a process that keeps fairness in play, we're going to kill what is a very important stability mechanism in this state, which is organized labor. Take it for what you want, but we've submitted the right thing to do in this case is grant the application, just jump right to reversal of the Court of Appeals.
Thank you, counsel. Mr. Porter.
Good morning, may it please the court, David Porter here on behalf of Dan Renner, who is here today with me in the courtroom. I welcome the court's questions at any time. The
Well,
union in this
how about,
case
if you're gonna do that, let me just start. Respond to his argument that Janice actually works in their favor.
It doesn't. What Janice was referring to was the statute that the legislature could enact that would impose a lesser burden on non-members' First Amendment rights. That's the only thing that they were talking about. That you can see that in the authority that they cited, the California statute, and there are dozens of other statutes across the United States. Michigan does not have one of those statutes. The legislature tomorrow could enact a statute that Mr. Guido wants to have in place, and it would solve all of our problems. But they haven't. And in fact, they enacted a statute that signals to this court that they do not want the result the union is asking for in this case. The union enacted a right to work statute that prohibits the assessment of fines, fees, any cost whatsoever as a condition of continuing employment. They also have statutory language that prohibits the union from coercing the members in the exercise of their statutory rights, one of which is to refrain from union membership. So the primary question in this case is whether or not the fee-for-service provision in this case violates that statutory prohibition. When Mr. Guido asks or says that there's nothing in the statute that prohibits this, it's that language right there. Now, in order to answer that question, I think it's important to correct a very important but false premise in the union's argument. I'm concerned because the case as it's been presented to the court rests on a fundamental misunderstanding or misrepresentation of the duty of fair representation. And that is a key aspect to the analysis of whether or not this is coercive. According to the largest public sector unions in this state, the AFL-CIO, AFSCME, AFT, MEA, they all agree with Mr. Renner that this is a violation of a duty to fairly represent Mr. Renner and all members of the bargaining unit. They are philosophically opposed.
How is that? I don't get it. How is that? He's still getting the collective bargaining benefits, right? How is this, I mean, how is this not just, as brother counsel argued, how is this not just specific and individual matter that this person has?
So
He gets, let's go through. He gets all the benefits, right? He gets all the benefits of the collective bargaining agreement. This is a unique, highly specific, highly focused issue that is specific to him.
he gets all the benefits of the collective bargaining agreement, but he also gets all of the burdens. The union in this case, as the exclusive
What
bargaining
burdens
representative-
does he get? He hasn't paid for anything. But what's his burden? I'm confused. What's his burden?
Mr. Renner no longer has the freedom and his right to deal directly with his employer about the terms and conditions of his employment. That power rests.
How is that?
exclusively-
How is that? He can't get it. This is a direct cost for service, right? He can't get his own lawyer. He can't, no one's saying he doesn't have the right to do it. He could represent himself, right?
No, he could not. Under the contract, he has to go through the union. The union, exercising its power as exclusive bargaining representative, reserved to itself the sole access to the contractual grievance process.
But we're talking about more just the vehicle in terms of how he exercises that, right?
Excuse me, say that
The
again?
vehicle, right? The vehicle is the
They
vehicle.
hold the access key to the most important term and condition of Mr. Renner's employment. If he has a dispute with another employee or his employer, if his employer fires him without just cause, he is unable to vindicate his rights and keep his employment unless and until the union represents him and pursues that grievance. Now, Mr. Renner understands that the union does retain discretion and control over whether and how far that grievance should go. Mr. Renner is not questioning that power. What he is saying is that the union has a duty to treat him on the same terms as it does every member of the bargaining unit. And what they've done in this case is charge him a fee that they do not charge anybody else in the bargaining unit. Mr. Guido says that union members pay dues in exchange for these services. absolutely do not. The union has a duty to provide these services to every member of the bargaining unit, regardless of whether they pay. If the court adopts the principle of mutuality of obligation as the sort of the rationale or theory for union representation, that will destroy decades of labor principles. This is made clear by the amicus brief filed by the largest public sector unions in this state. They are concerned that adopting the union's position in this case will wreak havoc on their power as exclusive representative over the bargaining unit.
So along those lines, I mean, should the Court of Appeals have just held that this was a breach of the duty of fair representation and left it at that? I mean, I think that that's what the amici suggests is, you didn't need to go any further than that, right? And all the other stuff.
It was not unnecessary because, let's take us back, Mr. Renner filed an unfair labor practice, and the ALJ construed it as bringing two charges, duty of fair representation and a violation of their duty not to coerce. The ALJ and the commission found both of those violations and required the union to post a notice based on both of those charges and based on both of those violations. The union then goes up and contests both of those findings. The union had everything to gain by the Court of Appeals addressing both violations because they could have been found not to have engaged in that second ELP. So it was not unnecessary to the Court of Appeals opinion. I also like to address the other aspect of the union's argument on that front that, well, we just don't know from the record whether or not this was coercive. That's wrong. Mr. Renner, in his email to the union, said he felt threatened, bullied, and intimidated. And he also told the ALJ in this case that he felt that he was being threatened.
So it's just subjective, how he felt?
No, so I was just responding to the point that the amicus brief is making that there are facts in this record to support the finding. It is our position that it is an objective standard of what a reasonable person would think, because we really think it's sort of beside the point. Also, on top of that,
But it's important, I mean, obviously coercion is a big part of this case if you're gonna find a violation of 423.210, so I'm just wondering what was coercive here?
to charge a fee to a non-member to gain access to the most important term and condition of their employment based on an unknown, uncontrollable, and significant cost, the purpose and effect of which is to dissuade them from leaving the union, that is coercive. As the Court of Appeals pointed out, the union in this case first negotiated for itself exclusive control over this very important part of the collective bargaining process and the CBA, is access to the contractual agreements. And then it turned around and imposed a fee that has cost prohibitive nature, is due on a short time frame, and they held, quote, faced with that economic reality, employees who would otherwise exercise their Section 9 rights could feel compelled to join the union if only to avoid the risk of forfeiting a meritorious grievance. Now, I want to point out, the union in this case has not demonstrated or argued why that holding is wrong. They have not explained any rationale why that's not coercive. They instead jump right to, coercive or not, it's okay because this is an internal rule that is limited to union membership. Now, that's wrong because it applies by definition to people who are not members of the union. And that's what this proviso is speaking to. Retention and acquisition of union membership, not bargaining unit membership. If that were the case, then any union policy would be exempt from what Mr. Guido is saying is their duty not to be coercive. On top of that, the MERC and Court of Appeals have held that this proviso does not give them a license to violate employees' Section 9 rights or interfere with their relationship with their employer, which is precisely what this means.
But Counsel, your argument is, I mean, again, going to just equitable nature of this, your argument basically is that your client basically should have access to this service at the cost of the union, even though that your client doesn't pay any dues or do anything to contribute to that. So it's not only in this situation is what your argument is that he gets to benefit from the fact that the union is is arguing on his behalf, is doing a collective bargaining on his behalf, but this is really what it all comes down to, and I think we're just gonna go in a circle, but really this is the essence of it is, you have a person that is not paying and insisting on not paying, and then ultimately coming and saying, hey, I'm not paying, but in addition to me not paying, I have this individual issue that I'm impacted by, and I expect you to represent me. Under that situation, how is this not anything other than a way to destroy organized labor?
Okay, I agree with you that it does feel like we're going around in circles in the briefing about whether or not this is fair or that is fair. To your last point about how this will destroy unions, I mean, the fact that the largest public sector unions in this state have chimed in and said that they are, that what the union has done here is antithetical to the mission and purpose of a union, and that they are philosophically opposed to what they're doing, I think is exhibit A, that this is not going to destroy unions if this were to not lead. That's the first thing. The second thing is, if we're talking about fairness here. Let's assume for the sake of argument that there is an element of unfairness to this aspect of the labor law sector. I would submit that acknowledging a problem is not the same as solving it. I think that's a very important point, because if we can.
So we should acknowledge that this is completely unfair, but that's where we should just stop.
No, what we're saying is that if we acknowledge that there is an element of unfairness, it doesn't mean that what the union did in this case is proper. The sole question before the court is not whether this is fair or unfair, but whether or not what the union did was coercive of Mr. Renner's Section 9 rights or violated their duty to fairly represent him. That's the only question before the court. Now, if we do want to talk about fairness, it's important that context and perspective matters, because this is a complex ecosystem. And if the court starts deciding cases.
It's a complex ecosystem because your client basically doesn't want to pay, and then he's demanding an additional service that's unique and specific to him.
It is a complex ecosystem because the legislature enacted PARA 50 or 60 years ago because they wanted to achieve a higher purpose of the benefits that would come from a collective bargaining system. Remember, this doesn't exist sort of in nature. The legislature created this entire framework so that employees would be able to bargain better with their employer about the terms and conditions of their employment. But with that common good comes at the expense of certain individual rights, including the rights of people like Mr. Renner, who now can no longer go to their employer, for instance, and ask for a raise because they think they have been performing well. They cannot do that. That power rests exclusively in the union, and the union has to treat every individual in the bargaining unit on equal terms. So there are elements of unfairness. I mean, it's not Mr. Renner asking the union to do this. He must ask them to do this. He cannot go to his employer to pursue his contractual grievance. The union made sure of that when they negotiated the contract.
Let me ask something that tails off of that. If we adopt mutuality of obligations as a guiding principle of labor law, would workers be permitted to bargain directly with their employer and without union representation?
That would be the end result. You take their logic all the way to the end point. What you're going to have is the balkanization of a unionized workplace. Because I understand the union in this case wants to draw the line between direct services and collective services. The logic doesn't stop there. If the duty to represent somebody depends on financial consideration, then the union has no obligation or power to bind people like Mr. Renner in the first place. They cannot enter into a contract that forces them to use their services in order to achieve the rights and privileges that are enshrined in that contract. That's an adhesive contract. And on top of that, you could easily see a union negotiating a contract that has different terms and conditions depending on whether or not the person has financially supported the union. And now your unionized workplace.
But isn't it, this is individual though? This isn't, I understand what my colleague is saying, but this is individual. This is an individual person who had an individual issue that doesn't affect the overall unit.
So two things.
This is his thing.
So two things to that. One, I believe the opposing counsel has already conceded that the logic would also apply to collective action as well. The second is individual grievances are not limited to the individual employee. They affect the welfare of the whole. That's been recognized by U.S. Supreme Court and Merck decisions for many decades. That is why the union has such strong control over the pursuit of individual grievances. They have incredible power to stop Mr. Renner from pursuing a grievance because of cost, because it would affect the welfare of other employees, for a number of reasons, all tied to the merit of the grievance. But it has to be tied to the merit of the grievance, not whether or not Mr. Renner pays some extortionate fee in order to access one of his own.
So is a fee ever allowed? If they're allowed to get past, to file the grievance, get a look, the union helps with some internal stuff, and then they're gonna go to arbitration where, let's face it, lawyers are expensive. Is some sort of fee structure allowed then?
No, you cannot condition an employee's access to their contractual rights on the payment of a fee. And this is, let me make this very clear. They would not do the same to a union member, so they cannot do it to a non-union member. You cannot discriminate.
What about Brother Counsel's argument, which I think I heard him make, was that they are distinguishing between grievances that are very individual versus ones that can affect the bargaining unit as a whole, the collective?
That distinction is illusory, because even the very individual grievance does affect the welfare as a whole. It'll set a precedent with the employer. And it could affect, for instance, if you're a janitor, it could affect the welfare of the other janitors depending on what the employer does.
What's going to prevent every union member from seeing this and saying, I'm going to stop paying dues? All of us should stop paying dues, because we're going to get the protections and coverage from the union regardless.
So at the end of the day, that is a policy problem for the legislature. I think if the result that Mr. Guido is worried about, which hasn't happened, by the way, and we see that from the amicus unions brief, there has not been this exodus from public sector unions because of right to work. Mr. Guido himself said that only a handful of their bargaining unit members have left. But let's assume that they leave in droves. That is a policy problem for the legislature to fix. Let me make this last part very clear. Unions do provide a good service. We do not want them, and certainly Mr. Renner does not want to lead them to death. But if that problem does come to light, that is a legislative fix, that is a policy problem. It's not something the union can fix on its own, because this is a complex ecosystem. When you start tinkering with the machinery, you start affecting the rights like people like Mr. Renner.
Counsel, I wanted to just, first of all, thank you. We're peppering you with lots of questions, so thank you for your clear answers. I am very appreciative. I wanted to just turn back to Janice, because that's really the reason we're here. And the language, which talks about, quote, individual non-members could be required to pay for that service or could be denied union representation altogether, where the court had sort of engaged in an analysis of less restrictive means for the state to be involved with membership rights and First Amendment rights and all of the reasons that underlied the Janus decision. It then drops a footnote, which is, I think, the point you're talking about. There is precedent for such arrangements. Some states have laws providing that, and they give examples of where fees are permitted. And then it says, e.g., California, Illinois, some other examples. E.g. obviously means for example. So I recognize the cited example is a statute, but does that, so are you saying that prohibits courts from interpreting their laws? It can only be statutes, and courts can't interpret our statute to perhaps allow fees under this context?
No, the point is that the U.S. Supreme Court certainly wasn't instructing this court that it had to read out of its own statute the obligation not to coerce members in the exercise of their statutory rights. The Supreme Court also did not mention the decades of NLRB precedent that had struck down the very types of services that Mr. Guido and the union here imposed. So it's a thin read.
Which that's under the duty of fair representation, correct?
No, under both. They say that it's a duty of fair violation of that duty and coercive of the employee's rights under their analogous Section 9. So this has been sort of beyond debate for decades, and to think that the Supreme Court, with some offhand dicta, meant to upset decades of NLRB precedent with the citation of, for example, I think is a big leap, and I certainly wouldn't rely on that to misconstrue our own state statute. Unless the board has any other questions.
Thank you, counsel.
Actually, Chief, before we submit, well, I'd like to hear from Mr. Guido if he could respond to, I think I just want to have a better understanding of this exclusivity that counsel is speaking about in terms of, if Mr. Guido, if you could just speak to this argument that was put forth, that the exclusivity argument, that if a person doesn't have a choice but to go through the union in order to address a grievance.
All right, well, initially, this brings up the old saying that I could agree with brother counsel, but then we both be wrong. and that is the very case. With regard to exclusivity, I mean, some of what brother counsel has said is not inaccurate in the sense that, you have a collective bargaining agreement, the union has control of the collective bargaining agreement process. But what is being missed in this argument are two important facts, and I hear it repeatedly in The two important facts to be not forgotten is this perception that somehow when a member is paying dues, that's not a payment for services. And that's ludicrous. That's precisely what they are doing. They're paying for that benefit when they need that benefit to occur. We are simply asking for the appellee to pay for that service if he asks for that service, because we're willing to deliver that service. So from an exclusivity standpoint, yes, he has to go through the collective bargaining agreement process. That's not an evil thing. That's a good thing. He's got an alternative dispute resolution mechanism built in and available. He simply has to step up and say, I want to use this process. I would like to pay for this process because I know that the members are paying dues for this process, and I want to be treated equally to do that. And that's all this case is about. You know, to say that we have issues such as the Janus case, Janus is not that limited to what counsel is asserting. Janus opened the door with a comment, yes, to instruction. But this court, many courts, have taken words of the U.S. Supreme Court and have utilized those words to alter other things in their state. This isn't a case about the legislature having to allow us to do this. Legislature already allows us to do this. This is a case about if the legislature wants to restrict what we want to do. If they want to say, here's the amount you can charge, here's the method you can charge it with, then let the legislature do that. But until they do that, we shouldn't be labeled as a violator of the law having committed an unfair labor practice. That's simply wrong to do that, and there's nothing in that statute that prohibits this. Remember one important thing also. Everything in the law that we have, all the cases, all the discussion, they were all in existence because agency shop still existed. And Janus said that that was unconstitutional. All the analysis of the NLRB before that, all the other cases, they're all pre-Janus, pre-kind of right-to-work cases. They don't help us really answer this question. Yes, is it unique? But it's unique for a good reason, because the statute allows it. And I'm going to ask, with your indulgence, to say one further thing. I appreciate the fact that amicus, which was a consolidation of several unions, wrote a brief in this case. But I'm going to say it as a 42-year labor lawyer from my perspective and our opinion. That was a very targeted brief to this court. They are a competitor union to this union, and I find some of their comments to be very disingenuous in terms of what the state of the law is in Michigan and what the state of the law should be going forward. We're very passionate about this because we want to see organized labor survive, and we see this as a road and a path to its destruction in the law that gives us a protection that we believe is already there. Thank you. Appreciate it.
Thank you, counsel. Thank you both. The case will be submitted.